At precisely 11:15 this morning, something extraordinary happened in a New York courtroom. The proceedings in the civil fraud trial didn't simply pause for a routine objection or a scheduled break. Instead, they erupted in a moment that will likely be studied in law schools for years to come. Judge Arthur Angeron brought his gavel down with such force and authority that it stopped the defense team mid-sentence, freezing their argument in its tracks. This wasn't a display of judicial temperament or an emotional outburst from a frustrated judge. This was something far more significant. This was a deliberate, calculated intervention by a jurist who recognized that the defense had crossed a line so fundamental, so offensive to the basic principles of law, that he had no choice but to protect the integrity of the legal record itself. The defense had just attempted to argue that this case involved a victimless crime, claiming that because the financial institutions were eventually repaid in full, no fraud had actually occurred. That assertion is what triggered the explosion in the courtroom. And when you examine the evidence, when you look at the financial documents, when you follow the trail of numbers and sworn statements, you'll understand exactly why the judge had to intervene. I have the financial documents right here in front of me. The statement of financial condition that triggered this courtroom confrontation is not a matter of interpretation or political perspective. Before anyone dismisses this as partisan theater or a politically motivated prosecution, they need to look at the spreadsheet. This document isn't about ideology. It's about arithmetic. It's about objective, verifiable numbers that either add up or they don't. The judge has ruled that over $2 billion in asset value was fabricated. Let me repeat that figure because its magnitude is difficult to comprehend. $2 billion. This is not a rounding error that occurred because of different accounting methodologies. This is not a difference of professional opinion between two equally qualified appraisers. This is a business model that was constructed on a foundation of objective falsehoods. I've spent decades prosecuting financial fraud cases in federal court. I've seen every variation of creative accounting, optimistic projections, and aggressive valuations. I know the difference between an entrepreneur who genuinely believes their property will appreciate and a defendant who is committing a criminal lie. What happened in that courtroom this morning was a judge drawing a clear line in the sand. He refused to allow the defense to transform the courtroom into a campaign rally where facts are optional and truth is negotiable. There are two critical pieces of evidence that the defense is desperately trying to hide from public view. First, there's a specific disclaimer clause in the financial documents that they claim provides them with legal protection from liability. Second, there's an internal email from the bank, a communication that they undoubtedly prayed would never see the light of day. I'm going to show you both of these documents and explain exactly what they mean. Let me walk you through the specific numbers that made the judge slam that gavel with such force. When you see the mathematics, when you understand the scope of the discrepancies, you'll comprehend why he had no alternative but to intervene. I'll be breaking down these financial documents piece by piece, examining the evidence rather than the spin, following the facts rather than the rhetoric. If you want to follow this evidence trail without the partisan noise that surrounds this case, I encourage you to follow along. I'll be here for every filing, every motion, every piece of documentary evidence that emerges from this trial. Let's start with the spreadsheet that initiated this entire legal proceeding. Let's examine the documents with the kind of forensic scrutiny they deserve. Specifically, we need to focus on the Statement of Financial Condition. This is the foundational document that the defendant submitted to financial institutions to secure loans worth hundreds of millions of dollars. In the Southern District of New York, where I spent years as a prosecutor, we call this the foundational document. If this document contains lies, then every dollar borrowed based on those falsehoods is the fruit of fraud. The entire financial structure becomes tainted. First, let's examine the valuation of Mar-a-Lago. In the financial statements that were submitted to banks, This property was valued as high as $739 million. The defense has argued that this valuation was based on the property's potential use as a private residence, calculating its worth based on the luxury real estate market in Palm Beach. But here's where the mathematics become devastating. I have the tax assessment records right here. When it came time to pay property taxes, the same organization fought aggressively to have the property valued at a dramatically lower figure, approximately $18 million. You cannot operate in both directions simultaneously. You cannot tell the tax authorities that a property is worth $18 million to minimize your tax burden, and then turn around and tell a bank that the same property is worth $700 million to secure a loan. This is a discrepancy of over 2,000%. That's not a mistake that occurred because someone misplaced a decimal point. That's not a difference of opinion between two appraisers using different methodologies. That is a deliberate strategy of valuation manipulation depending on the audience. Second, let's examine what is perhaps the most objectively provable instance of fraud in this entire case: the Trump Tower triplex. The financial statements submitted to lenders listed this apartment at 30,000 square feet. That number wasn't just mentioned in passing. It was used as the basis to calculate a value of over $300 million. But square footage is not a matter of opinion. It's not a subjective judgment call. It's not something that varies depending on who's doing the measuring. Square footage is an objective, verifiable fact. It's a number that can be measured, confirmed, and documented. The actual size of the apartment is just under 11,000 square feet. The financial statements claimed it was 3 times the actual size, which conveniently allowed them to claim it was worth approximately 3 times the actual value. When you sign a legal document certifying that an apartment is 30,000 square feet, and you know with absolute certainty that it is only 10,000 square feet, you are committing fraud. There is no other legal term for this action. This isn't aggressive marketing. This isn't optimistic projection. This is deliberate misrepresentation of objective fact. Third, let's look at the valuation of 40 Wall Street. The financial documents reveal that they inflated the value of this commercial building by nearly $200 million through a simple but illegal technique. They ignored the actual expenses of operating the building. They simply removed costs from the spreadsheet to make the net income appear higher, which in turn made the property appear more valuable. In the world of forensic accounting, this is what we call cooking the books. It's not a subtle technique. It's not sophisticated fraud that requires expert analysis to detect. It's clumsy, obvious, and unquestionably illegal. The defense will argue that everyone exaggerates a little bit. They'll claim that optimistic valuations are standard practice in real estate. That assertion is false. Honest business owners do not triple the square footage of their collateral. Honest homeowners do not claim their house is worth 50 times its tax assessment when applying for a mortgage. This pattern of behavior isn't accidental. When you see a discrepancy once, it might be an error. When you see it twice, it raises questions. But when you see the same pattern across multiple properties, across multiple years, involving billions of dollars in loans, it demonstrates intent. And that intent is what drove the judge's reaction today. But the defense has one main argument remaining: the victimless crime theory. Let me explain in detail why this argument is fundamentally a lie. The judge didn't explode because he was emotional or because he had lost control of his courtroom. He exploded because the defense was insulting the very foundation of law. The core of the defense strategy is straightforward. The banks were repaid in full. They made money on the interest payments. There was no default. Therefore, there is no victim, and this should be classified as a victimless crime. I've heard this excuse from white-collar defendants for decades. It sounds superficially logical, especially to people who aren't familiar with fraud law. But let me be absolutely clear about the legal standard. Under New York executive law, which is the statutory foundation for this case, you do not need to prove a monetary loss to prove fraud occurred. Here is the analogy I use to explain this concept to juries. Imagine a driver speeding at 100 miles per hour through a school zone. He drives recklessly, endangering everyone in his path, but by sheer luck, he doesn't hit anyone. He makes it to his destination safely. When the police pull him over, can he successfully argue, "Officer, nobody got hurt, so I didn't actually break the law"? Of course not. The crime is the reckless act itself. The crime is endangering the public, regardless of whether harm actually occurred. Financial fraud works exactly the same way. When you lie to a bank to get a better interest rate, you are stealing from the market. You are obtaining capital that you don't actually qualify for. You are getting a preferential rate that should have gone to an honest business that actually had the collateral to back it up. Just because the bank didn't lose money in the end doesn't mean the law wasn't broken. This concept is called market integrity. The entire financial system relies on truth. If we allow billion-dollar corporations to lie on their loan applications just because they might eventually pay the money back, the entire system collapses. It creates a fundamentally unfair playing field. Think about the small business owners who are seeking a loan. They have to verify every single dollar. They have to provide accurate tax returns. They have to document every asset. If they lied about their square footage by 300%, they would be charged with bank fraud immediately, and they would likely face criminal prosecution. The judge stopped the proceedings because the defense was asking for a special set of rules. They were arguing that because the defendant is wealthy and powerful, the rules of honesty shouldn't apply to him as long as the check eventually clears. That is what triggered the explosion in the courtroom. It was a defense of the rule of law against the idea that money buys immunity from the obligation to tell the truth. But the prosecution didn't just rely on legal theory and principle. They set an evidentiary trap, and they sprung it using the bank's own internal documents. The defense spent weeks arguing that Deutsche Bank, the primary lender in several of these transactions, didn't actually care about the statement of financial condition. They claimed the bankers were sophisticated financial giants who conducted their own independent appraisals and essentially ignored the defendant's self-reported numbers. This was actually a smart defensive strategy until the prosecution produced the receipts. I'm going to show you the document the defense desperately didn't want you to see. It's an internal risk assessment from Deutsche Bank dated 2014. This document details exactly how the bank decided to approve the loan for the Doral Golf Resort. Read this sentence carefully. The facility is being approved based on the financial strength of the guarantor. The guarantor is the defendant. The financial strength being referenced is the number he provided in that fraudulent statement of financial condition. This is what prosecutors call the smoking gun. The bank explicitly relied on the personal guarantee. They relied on his claim that he was worth billions of dollars. That claim was the bedrock of the loan approval decision. The prosecution let the defense walk directly into this trap. They allowed the defense lawyers to argue for days that the banks didn't care about the financial statements, that they did their own homework. Then they put the bank official on the witness stand and showed him this internal document. The witness testified that without the statement of financial condition, the terms of the loan would have been drastically different. The interest rate would have been substantially higher, the required down payment would have been larger, or the loan might have been denied entirely. That difference, the money saved by lying, is the ill-gotten gain. That is the fraud. According to the calculations, they saved roughly $168 million in interest payments by using these fabricated numbers. That is money that rightfully belongs to the bank. That is money stolen through deliberate deception. That single sentence in the risk assessment document destroys the entire defense strategy. It proves reliance. It proves the lies mattered. It proves that the bank didn't just do their own independent homework. They trusted the homework the defendant turned in, and that homework was forged. This is why documentary evidence matters more than opening statements and press conferences. You can say whatever you want to the cameras in the hallway, outside the courtroom, but inside, documents like this one are bulletproof. Having lost on the mathematics and lost on the bank reliance argument, the defense has retreated to their final desperate position, what they call a disclaimer clause, but what the judge has called irrelevant. The final line of defense is a disclaimer statement in the financial documents. The text essentially says, assets are stated at their estimated current values. Users of this financial statement should not rely on it without conducting their own independent verification. The defense argues that this clause gave them permission to lie. They argue that because they warned the bank not to rely completely on the numbers, they can't be sued for fraud when the numbers turn out to be fake. In contract law, we have a fundamental principle. Fraud vitiates everything. That means you cannot disclaimer your way out of intentional deception. Think of it this way. You cannot sell someone a rock, call it a diamond, and then point to small print saying, "This might actually be a rock." If you knowingly misrepresented the item as a diamond to get the price of a diamond, you committed fraud. The disclaimer doesn't protect you from the underlying lie. It actually proves you knew you were lying. I've seen this defense attempted before in numerous cases. It never works. You can't sign a document swearing it's true under penalty of perjury, then point to fine print saying, "I might be lying." The law requires good faith dealing. When you submit a statement of financial condition, you are certifying its accuracy to the best of your knowledge. The judge has ruled on this specific issue. He stated explicitly that these disclaimer clauses do not insulate the defendant from liability for intentional fraud. He noted that the disclaimers were nonspecific and did not cover the massive intentional discrepancies we discussed earlier, like tripling the size of an apartment. That's not a legal loophole. That's actually a confession. By relying so heavily on this disclaimer clause, the defense is essentially admitting the numbers were wrong. They aren't arguing anymore that the numbers were accurate. They are arguing that they shouldn't be held responsible for the inaccuracy. This is legal desperation. It's the argument you make when you have no facts on your side. You stop arguing, "I didn't do it," and start arguing, "You shouldn't have believed me." But the consequences of this defensive strategy failing are absolutely catastrophic. We aren't just talking about a fine that gets paid and everyone moves on. We are talking about what amounts to the corporate death penalty. Most people following this case are focusing on the money, specifically the $250 million fine the Attorney General is seeking. But that number, as massive as it is actually the least of the defendant's problems. The real existential threat is the cancellation of the business certificates. Under New York law, if a business persistently engages in fraud, the state has the power to dissolve that business entity. The judge has already indicated he is moving in this direction. He has ordered the cancellation of certificates for the entities that hold the key assets. This isn't just about writing a check. It's about losing the license to do business in New York. Imagine having to hand over the keys to a court-appointed receiver. That is what is actually on the table. A court-appointed receiver would step in to manage the dissolution. They would take control of the properties. They would manage the bank accounts. They would oversee the sale of assets to pay the fines and disgorgement. The defendant would lose control of his own empire. He would no longer be the decision-maker for the buildings that literally bear his name. This also brings us to the concept of disgorgement. Disgorgement isn't a fine in the traditional sense. It's a refund to the public. It is the legal mechanism of forcing a fraudster to give up every penny of profit they made from their illegal acts. The court calculates exactly how much money was saved in interest payments and how much profit was made from deals secured through fraud. that entire amount must be paid back. If the defendant cannot pay in cash, the receiver sells the buildings. It is that straightforward. The defense will appeal, of course. But here is the fundamental problem with an appeal in this case. Appeals courts look for errors of law. They don't rewrite the factual findings. And the facts in this case are damning. The discrepancy in square footage is a fact. The difference between tax assessment and loan valuation is a fact. The bank email proving reliance is a fact. An appeals court is very unlikely to overturn a judge's findings on these hard numbers. This matters because if this behavior is allowed to stand, if wealthy defendants can lie about their assets with impunity, the banking system becomes a casino. If the biggest players can lie about their assets, then banks have to raise interest rates for everyone else to cover the increased risk. Small businesses pay more. Homeowners pay more. The entire system relies on trust. When that trust is violated on a billion-dollar scale, the punishment must be severe enough to restore faith in the market. The timeline for the appeal is strict under New York procedural rules. The receiver could be in place within weeks of the final judgment. The liquidation of assets could begin shortly after. This is the end of the road for the business-as-usual approach that relied on bluster over balance sheets. The facade has been stripped away by forensic accounting. Now we simply watch the legal process unfold. You can bluster in a press conference, but you can't bluster a balance sheet. The judge's explosion this morning wasn't just about judicial frustration. It was the sound of reality crashing into a fantasy world. For decades, the defendant has operated on the belief that if you say something loud enough and often enough, it becomes true. But in a court of law, truth is determined by evidence. It is determined by signed documents, bank records, sworn testimony, and objective facts. The system worked today because the numbers don't lie. The victimless crime defense collapsed because the law recognizes that truth itself is the victim when fraud becomes standard business practice. This is what accountability looks like in practice. It is slow. It is tedious. It involves thousands of pages of documents and countless hours of forensic analysis. But eventually, the check comes due. That's not a political threat. That's just arithmetic. Mathematics doesn't have a political party. A square foot is the same measurement whether you are a Democrat or a Republican. A dollar of debt is a dollar of debt regardless of ideology. The court has affirmed today that these objective standards apply to everyone, regardless of their wealth, their former titles, or their political connections. I'll be here watching the appeal process unfold. I'll be tracking the receiver's appointment. I'll be following the asset sales because the story doesn't end with the verdict. It ends when the judgment is fully satisfied. Facts matter, evidence matters, the rule of law matters. And today, in that New York courtroom, we witnessed all three principles defended by a judge who refused to let the courtroom become a stage for legal fiction.